Hi, who just joined the conference line?
This is Probation Officer Herman for Katherine Milton.
Thank you. This is Abby in the Juneau Courthouse. I was trying to connect with you all for a POLYCOMM for the 230s. Okay, thank you so much.
I just tried to call in, and it said all circuits were busy. I tried a couple times, and I was like, well, I'll just come down here, but I don't know.
I mean, there's like 10 people on the phone right now.
It wasn't even for your code.
Oh.
It was the 1-800 number. I dialed the 1-800 number, and then it'd say, we're sorry, all circuits are busy right now. So I tried a few times.
Sometimes it does that. I don't know why. It does it for us. I mean, if you want to be telling.
Well, I mean, I'll just sit here. So.
Hi, you just on the conference line?
LCC.
I'm sorry, can you repeat that?
LCC, the jail.
Thank you. Let me quick, are we not going to be POLYCOMM today, or is it just telephonic?
I was told it was POLYCOMM.
I'm trying to connect and it's not connecting to you guys.
You're above my pay grade. Oh, got plug it in. All right, try it now.
It's connecting. Nothing yet.
Yeah, I get paid to carry a gun, not to deal with technical shit.
It's not working.
I just plugged it in, so I might need a minute to power up. Do I try it again?
It's calling you on our end, but it's like you're not taking.
It's doing something on our end.
Are you calling courtroom C?
Yep.
It's telling me it's busy on our end.
Well, it took me a little bit to call in on the phone. It kept saying all circuits were busy, so, it's doing something now. I think it might be connecting.
I got something 3 months ago. I had no idea. I'm looking at 2 years. That was 3 years, 3 months ago. I don't know. I don't.
Better than an incoming call.
All I know is I'm the one.
Hey, there you go. We got the courtroom.
We got it.
All right. Yep.
All right, thank you.
Ooh, I'm a rebel just for kicks. I've been feeling it since 1966. Might have had your fill, I can feel it still. Ooh, I'm a rebel just for kicks.
The chairperson has disconnected. The conference will now end. Welcome to Ready Access by CenturyLink. Thank you. Please stand by. If you are the chairperson, press the star key now. Your conference will begin when the chairperson arrives. Please wait. You will now be placed into conference.
Sorry for everyone on the phone. Our phone line is glitchy today.
Okay.
It looks like we have everyone back.
You mean arraignment? The POLYCOMM?
All rise. You know Superior Court is now in session with the Honorable Judge Pallenberg presiding.
Afternoon, you can have a seat. So we're on record for a bunch of cases, and I see a room full of people at Lemon Creek. Why don't we, actually, before I take them, we have two people on the phone from Ketchikan Correctional Center, and I want to deal with those cases first. I have, there's just two of them. Brandon Riley and Corey Thompson. Let's start with Mr. Riley. Is Brandon Riley on the phone from KCC?
Yes, I am.
All right. Bear with me just a second. So I understand Judge Meade did a hearing yesterday, and I think there was actually, I'm not really clear from the law on what happened yesterday, but she set it over until today for a continued discussion.
Judge, hi, this is Ms. Willoughby. I represent Mr. Riley, and so Mr. Riley, we had a marathon pretrial hearing yesterday with pretrials and arraignments and bail hearings and such. Mr. Riley apparently sat in the telephone room in Ketchikan for approximately an hour and a half, and then the staff was unable to keep the folks out. And so, and then the lawyers held on the phone for another half an hour or so while they tried to get Mr. Riley and the other fellow back in, which was why I was late to the hearing, covering for Ms. Soutier yesterday.
Let me interrupt. So who do we have on the phone for the state on this case?
You have Ms. Gibson on the phone for all of the cases today.
Gibson is with us. So the matter was on for a discovery hearing yesterday, Ms. Willoughby, and I believe it's on the April trial calendar with Judge Meade. What's the status of this case, Ms. Willoughby?
Judge, I believe we are discovery complete. Mr. Riley has companion cases in Ketchikan. For those reasons and the current situation in the state and the country and the world right now, it seems really unlikely that Mr. Riley would be available to try a case in Juneau in early April. So as such, if we could move this to the May calendar, and I was set to visit Mr. Riley on tomorrow, had a ticket to visit him and other folks down in Ketchikan, but as the court knows, DOC is not allowing visitation anymore, so we're not prepared for trial. So if we could set it in the May calendar, it's likely a placeholder for now, but that would be my request. Mr. Riley is actively trying to get into inpatient treatment. We are not prepared to address release for that today because we don't yet have a letter with an appointment date for an assessment.
Ms. Gibson, do you have any objection to proceeding in that way?
No, Judge.
All right. Mr. Riley, things are in a mess right now in terms of the situation, and what Ms. Willoughby proposes makes sense to me. Do you understand that? Any questions about what she's talking about?
No, I don't.
All right. I will go ahead and order that the matter is continued to Judge Meade's May trial calendar. Hopefully things will get sorted out well before that, but that just gives some time to figure things out, because everything's a little up in the air right now. So that would mean a new set of dates as follows. A discovery hearing, April 8th at 8:30 in the morning. If Mr. Riley is still in custody, and he can certainly be telephonic, or if he's still in custody or not, he can be telephonic for that hearing. Pre-trial hearing, May 4th at 8:30. Mr. Riley can also be telephonic for that hearing. Jury trial, in the event the case proceeds to trial, would be May 11th at 8:30 in the morning. Ms. Willoughby, any questions, anything else beyond what we've done?
No, thank you, Judge.
Ms. Gibson, anything else on Mr. Riley's case?
No, Judge.
All right. Mr. Riley, any questions about any of that?
No.
Thank you, sir. I'm sure Ms. Willoughby will be in touch with you. The other catch-can case, or the other case we have with a person in catch-can is Corey Thompson. Do we also have Mr. Thompson on the phone from catch-can?
Yeah, I'm here.
All right, and I believe Mr. Kovac represents, actually, I'm not sure who represents Mr. Thompson. It says Public
Mr.
Defender
Kovac.
Agency.
Yes, Your Honor, Joe Kovac here.
All right. Ms. Gibson is with us for the state, Mr. Kovac for the defense. This case, I think, is in a pretty similar situation to the last one. I think there was a length of time Mr. Thompson just wasn't able to hang on the phone for reasons having to do with the jail in Ketchikan. Mr. Kovac, where do we stand on this case?
Your Honor, we're still trying to get my client into a long-term treatment program. We got a few things on the horizon in that regard. But I think we can go ahead and set this case for a change of plea. But given the things that we're working on, I'd ask that we set that approximately 2 months out.
Months. Ms. Gibson, any objection to that?
No, Judge.
Let's pull up the calendar. Certainly we'll set it that far out if things get sorted out and treatment gets set up or whatever else is done. I'm certain that Judge Meade would be happy to set it on a earlier calendar than that and get the matter resolved sooner. But that'll give us a court date in the event that doesn't happen. Would propose to set this on Judge Meade's calendar for, hang on a second, I'm sorry, I'm looking at my calendar. I gotta go over to Judge Meade's. Give me a second. Here we go. Tuesday, May 10th. Actually, no, I'm sorry. I'm looking in the wrong month. Let me do that one more time. Tuesday, May 12th, 2:30 p.m.
Works for me, Your Honor.
That works for me.
All right. The court dates before then, the trial date would be vacated, set for change of plea, but in the event, again, if there's a need to come back and do something different, just let the court know and we'll set it on sooner. Mr. Thompson, any questions about any of that?
No, thank you.
Thank you. All right, so I think we can let Ketchikan go, and let's turn to the folks that we have there in the room at Lemon Creek. And I'm just going to go down the line in the order that they appear on a calendar, which I think is alphabetical order. And the first up, Vigil Bradley. Is Mr. Bradley there?
He's coming up now, Your Honor.
All right.
Present.
All right. So this is State of Alaska versus Vigil Bradley. Matters on the calendar for arraignment on an indictment issued by the grand jury on March 12th. Mr. Bradley, have you seen a copy of that indictment? You seen the charge?
Yes, I have.
All right. Mr. Miller is here in the courtroom from the Public Defender's Office representing Mr. Bradley. Mr. Miller, you want me to read that indictment and set out and inform Mr. Bradley of his rights and the possible penalties?
That's fine, Your Honor. We'll waive reading and he'll enter a not guilty plea.
A not guilty plea being entered, I will set the matter for trial. Looks to me like, bear with me a second, first court appearance was March 4th, which is also the date of the charging document. So it would appear to me that Rule 45 started on that date, March 4th, which would mean the 4-month rule would expire approximately the 4th of July. I would propose to set this on the June trial calendar, which would be a trial date of June 1st, 8:30 in the morning. Pretrial May 26th, 8:30 in the morning. Discovery hearing April 29th, 8:30 in the morning. Bail and conditions were set in district court, $5,000 cash performance. I think Mr. Bradley also has some other cases pending. I don't have those files, and I don't know the bail status on those. You want to be heard on any of that today, Mr. Miller?
Well, I'll say for Mr. Bradley that I have spoken with a colleague of his or a friend of his, Ms. Phipps, who's willing to work with me on a bail proposal. I'd like to talk to you and talk to her before we go forward with the court. So maybe you can give me a call at my office, and I haven't heard from you yet. So we can do that. Maybe we can get something back on the calendar very shortly, Mr. Bradley.
Mr. Bradley, you know who your lawyer is, Mr. Miller, that was speaking, and how to reach him? You want to give him...
Yeah, Mr. Bradley, I haven't heard from you, and if you'd please give me a call, it's, I don't know if Officer Iler's there.
I can't give you a call because I can't use the phone.
Well, Mr. Bradley, I
can't do that myself. Well, it's so guilty. Just get this over with. I'm guilty.
I will set something up to talk to you on the phone. I can't go there in person right now, but they're letting me call in now, so I will do what I can to talk to you as promptly as possible, hopefully tomorrow morning.
Mr. Bradley, I know things are kind of messed up right now, and phone access, and you being stuck there without visitors. I know it's not ideal. The whole world's dealing with a situation right now. None of it's your fault. And I'm sure Mr. Miller will try to work through that with you as best he can. He said he will make arrangements to get you on the phone, and you'll have a chance to talk to him. We're dealing with what we're dealing with, and I can't do anything about that.
That's why I want to make it simple. Guilty.
Talk to Mr. Miller about that. It's not something we can do right now. You need to talk to your lawyer about that. Some things have to get patched before that can happen.
Cool.
Right. So, Mr. Bradley, let me just explain one other thing. I mean, I've set a bunch of court dates and a trial date. That doesn't mean the case has to be pending that length of time. If you want to do something different, talk to Mr. Miller about that once he can get you on the phone. I'm happy to schedule a court date much earlier than that to get things dealt with if that's what you want to do. But it's something you need to talk to your lawyer about and not talk here in front of everybody, okay?
I really don't need a lawyer.
You got one.
I'm guilty. Point blank.
Bradley,
2 years. That's what I was told earlier. 2 years.
I've spoken with your friend Ms. Phipps, who feels like you should just give a minute to this.
That is?
Take a breath, Mr. Bradley. Talk it over with your lawyer, and he'll figure something out. Next case I have Dale Hicks on the calendar. I'm not sure that Mr. Hicks is here. We'll get to you. We'll deal with these folks first. Mr. Iler, I see there on the video. This is State of Alaska versus Patrick Iler. And let me grab that file. All right, so this is on the calendar for arraignment on an indictment that charges misconduct involving a controlled substance in the second degree, misconduct involving weapons in the third degree, misconduct involving controlled substance in the third degree. 2 more counts of that. So it's total 4 counts. Mr. Iler, did you get a copy of the charges, the indictment?
Yes.
Mr. Iler, did you get a copy of the charges?
Yes, I did.
All right. Mr. Miller, you want me to...
No, thank you, Your Honor. Please, we'll waive reading and advise on enter not guilty.
All right. Let's see. I think this case has this... Well, the charging document is dated the... Charging document is not dated, but the date of the charges... Actually, it looks like this must be March 4th. Here's that Rule 45 started running March 4th on this case as well, which would put this on the same Rule 45 schedule as the last case. Would propose to set this also on the June calendar, which would mean trial date June 1, pretrial May 26, discovery hearing April 29. I'm sorry, those are all my dates that I just gave you. This case actually is assigned to Judge Mead. I would note that Mr. Iler's had a prior case in front of me. Normally, cases stick with the same judge, and it would have been assigned to me. I'm not sure that, I think that didn't get caught, and it is assigned to Judge Mead. It's possible that there'll be a change in that, but at this point, I should set this on Judge Mead's calendar. Her June dates are trial date June 8th, pretrial May 19th, a bit earlier than normal, and a discovery hearing May 6th, all of those at 8:30 in the morning. Bail was set in district court, $25,000. And if there is an issue about bail, I think I'd probably set it for bail hearing with Judge Mead. Mr. Miller, you want to take up bail?
Well, I know that, I believe Mr. Iler spoke with Mr. Seid about bail, and we'll set in a bail hearing with Judge Mead sometime shortly.
All right, we'll wait for a written request for one, but it'll be, I'm sure, scheduled on short notice once a request is made. Mr. Iler, any questions about any of that?
No.
All right. Ms. Gibson, anything else on your end?
No, Judge.
All right. Next case I have on the calendar, again in alphabetical order, is Ms. Milton. Date of last versus Katherine Milton. I see Ms. Milton coming up. This is a probation revocation. It's actually, it shows for adjudication on the calendar today. Do we have a probation officer with us on the phone?
Yes, Your Honor, Probation Officer Herman.
All right, P.O. Herman's with us on the phone. Mr. Miller, how do you want to proceed with this?
You know, I think we should put this out. I spoke with Ms. Milton yesterday, but I haven't spoken with probation or the state prosecutor about this, and I think it'd be useful to get another week.
Ms. Gibson, any objection to that?
This is Ms. Wolfstead, Your Honor. It's my case,
All right.
and I've got no objection.
Bear with me 1 second. Monday is my day next week. That would be the 23rd, 2:30 p.m. I could set the matter over till then. Hopefully we'll have something figured out by then.
Yeah, I would request that, Your Honor.
Ms. Milton, I'm not wanting to drag things out, but everything's a little bit in an uproar right now, and this gives Mr. Miller some time to figure out the best course of action for you. I'm sure, well, do you want Ms. Milton to call you, or you want to make it?
Yeah, I mean, Ms. Milton, if you please try calling me again. I will also try to call you, but I think it's just easier if you keep trying to call me, because I haven't had a whole lot of experience or luck with the opposite of working on this new system.
Okay, that sounds great, but what time is a good time to call you?
Well, I would say tomorrow is a pretty good day for me, Ms. Milton. If you could call me after 9, hopefully I won't be on the phone with someone else when you call. That's what happens sometimes.
I know things are in a little chaos right now. I'm sorry about that. The world's dealing with the situation, but hopefully, I'm sure if you keep trying, you'll get through to him tomorrow and you can get this figured out.
Okay, thank you.
Nothing much else I can do right now. All right, so we'll come back the 23rd, 2:30. Next case I have, Lucas Schneider is on the calendar. Is Mr. Schneider there? I see Mr. Schneider.
I'm up, Your Honor.
Ms. Willoughby, I believe, on the phone for Mr. Schneider. Ms. Willoughby, you there?
Yes, Judge, and Mr. Schneider is we've tried to do sentencing for Mr. Schneider a number of times, and schedules have intervened, and Mr. Schneider is quite anxious to get sentenced. However, I don't think we should go forward today. I think it's important that I be in person with Mr. Schneider in court. And so, and your judicial assistant yesterday contacted me. This is a piece of information that Mr. Schneider doesn't have, asking if we were going to go forward today, and if so, then she would have arranged to have Mr. Schneider transported. And I said, no, I didn't think that was a good idea. And so I know Mr. Schneider's going to be frustrated by this, but I think we need to be, both of us, there in person in front of Your Honor. The delay will not keep Mr. Schneider in custody longer than the proposed sentence that he'd already pled to would. So I would maybe we can set this in mid-April, and hopefully things will have calmed down to the point where we can all be in the same room. But I would leave that to the court's discretion and whatever works for the probation office and the district attorney's office in the court.
So I will say my reading of the statute is that it is not, I think, possible to do a sentencing, well, without having a defendant in the courtroom. I think the statute requires fingerprinting to be done in open court, and so it is required that he be transported. I can do it. I mean, and I think, and that can happen. If we need a prisoner, we'll get them transported for hearing. Ms. Willoughby, when are you back in town? I would do this as soon as you're back, whenever that's possible.
That is a good question, Judge. I'm supposed to be back currently at the I think it's March 26th. However, there was the notice that went out about quarantining for 2 weeks upon returning. I don't know from out of state. I don't know if that is going to be in place, what the situation is going to be. So, hence, that's why I chose mid-April.
Understood. And I don't know those rules either, and I think that we're probably going to get an order from the Supreme Court about courthouse access here probably by tomorrow that will clarify that. Is it Ms. Gibson for the state on this?
It's Ms. Wolfstead, Your Honor.
Ms. Wolfstead, any objection to setting this off as Ms. Willoughby requests?
No, Your Honor. I understand both Mr. Schneider and the victim want to see this move forward. However, I think in sort of the unprecedented situation that we're in, I think it makes sense. Mr. Schneider, I know you're anxious to get this resolved, and for good reason. I don't want to drag things out at all, but just as I've been saying, things are in a mess right now, and we're still figuring out the new normal with a weird situation that we've never dealt with before. I would propose to set this for April 14th at 8:30 in the morning.
April 14th.
You know, if everything gets back to normal sooner and we can do it sooner, I'm happy to. But I think what Ms. Willoughby suggests is probably the best we can do. And I certainly would be expecting that Mr. Schneider will be transported and will be here at that time. So April 14th, 8:30. Sentencing. All right, I have Rochelle Wood on the calendar, and I see Ms. Wood for bail hearing. Mr. Miller, are you here on this one?
I am, Your Honor, and I spoke to Ms. Wood maybe less than a week ago, and she gave me the name of someone who could help with this, and that person's phone has not been working. So our proposal was to bring Ms. Wood bail to $500 with EM and PED. I don't have a whole lot more to say in light of not having contact with anyone other than Ms. Wood on that.
So this is Ms. Gibson for the state.
Yes.
So, I'm sorry, Judge, do you have what bail is currently set at?
I was just looking for that.
My understanding was it was $1,500 between a variety of cases, and this was...
Yeah, I'm needing to look through a bunch of different files, because some of them have the last bail setting being unsecured on a bunch of files, and I'm trying to find the one that actually has some bail required. I have not yet come to that one. Here we go. All right, so it looks like in 20-265, Judge Swanson set the bail at $1,500. It's $750 appearance, $750 performance, and that is the VCOR case, it looks like, in which the allegation was that Ms. Wood failed to report to PED for drug testing on February 13th and then removed the battery from her ankle monitor on the previous day, on the 13th of February. I have a bunch of files, a bunch of violating conditions charges, and 191268 is the underlying felony case. All right, Ms. Gibson, you want to talk to me about what you think bail should be?
So we're here for all of her cases and not just the underlying felony?
I have all of the files in front of me. I don't think she's being held on anything. Actually, as I'm reading this, she's actually not being held on anything except the one VCOR involving the battery. That's where Judge Swanson set the bail. The bail remains unsecured, an unsecured appearance bond on all the other cases.
Okay. Judge, Ms. Wood currently, if you've got all the files in front of you, you're well aware of this, but I'll state it for the record. It looks like there are 4 violating conditions of release cases that are currently open. 2 from October, 1 from November, and then 1 from February, where Ms. Wood is being held on the $1,500 bail. I think that Ms. Wood has clearly demonstrated that she has trouble following the court's orders and that some cash bail is necessary for her performance, as well as her appearance. Ms. Wood sometimes only shows up to court when she's arrested on a bench warrant. If I could have just a moment to pull up her criminal history. It looks like Ms. Wood has a total of 9 prior convictions. From 2017, she has a larceny conviction. From 2012, a tampering with evidence, which is a felony. 2011, a mixed case, which was a felony, as well as driving without a license, and a theft 2, which is also a felony. Prior to that, she has a couple of other license issues, a DUI, a trespass, and a malicious destruction of property. So with the 3 prior felonies and the 4 pending violating conditions of release, I think that bail, as currently set, is actually pretty generous to Ms. Wood, and I would ask the court to maintain it.
Mr. Miller, am I right in understanding you're asking for a reduction and that there is some cash bail that Ms. Wood might be able to post?
I think Ms. Wood could be able to make, Ms. Wood has been released on, she's been kind of getting a break, I think, on some of those other cases, getting out without having to post anything, and now does have $1,500, which is well beyond what Ms. Wood could ever hope to come up with. But if it was down $500, I think that's something that not only it may still be a challenge for her to come up with, but I think there's a stricter consequence and stricter incentive to be showing up here at court or calling into court. That's what we're doing these days.
Well, I will say the pile of files I have in front of me certainly sounds like a person with a drug addiction. The original charge is a heroin charge dating back to October, and then a series of violating conditions charges for not coming in for drug testing and not keeping the electronic monitor going. Since Ms. Wood was arrested on that charge, she's been in custody a while on the $1,500 bail, and I think the Court of Appeals has made pretty clear that bail is supposed to be tailored to a person's ability to pay. Obviously, Ms. Wood doesn't have $1,500. If she did, she'd be out. And so, respectfully, I don't know that I think that any amount of bail that someone can't post is not generous to them. Whether it's $1,500 or $15 million, more than she has. I guess I feel like after a month in custody, one can at least, in theory, believe that Ms. Wood has detoxed from whatever she was using, and I guess I'm willing to reduce the bail, and if she's able to post it, give this a shot. I realize that Ms. Wood has a terrible track record, but let's give it a shot and see if she can do better. So I will reduce the bail to $500 cash performance. I will keep the unsecured bond that's been posted set on all the cases, $500 unsecured appearance bond. I will require PED, electronic monitoring, and drug testing. So you won't, if you are able to post the bail, you won't get released until PED comes by the jail and puts a bracelet on you. You did very badly with the bracelet before. Didn't keep your battery charged, you didn't keep your battery in it, you didn't come in for drug testing. If that happens again, I'll issue a big warrant and you'll stay in jail. But let's give it a shot and see if things go better. Just to clarify, the next court date on all of these cases is April 1st at 8:30, so really just a little over 2 weeks out. So if you're able to make bail, you got to be in court April 1st at 8:30. You may call in for that court hearing as well, given the current circumstances. But one way or the other, you'll have court on April Fool's Day at 8:30 in the morning, and we'll see where we are. Anything else on this case today?
Judge, could you please repeat the cash amount?
$500 cash performance, $500 unsecured assurance.
Thank you very much. I missed the first part. Nothing further.
All right.
That's all we had, Your Honor. We're signing off.
Thank you. All right. So let's come back to Mr. Hicks. Appreciate your patience. Come on up, have a seat.
Good evening.
I'm just need to make a note here, so bear with me 1 second while I make a note from the last hearing. All right. And then I'll grab the file. Got a big stack of files here, and they're all out of order, so give me a sec. Where is it? Yeah, I thought I looked at them all. Let me look through my whole stack one more time. Do not see Mr. Hicks' file anywhere in my stack. So the calendar says further proceedings on JU 20-365CR. I don't have a file. I have no idea what we're doing today. Mr. Miller, what are we doing here today?
I don't, Your Honor, I don't know what we're doing either. It just says district attorney on the calendar. I stuck around, so I didn't know if there was.
Ms. Gibson?
I have no notes on what's going on with Mr. Hicks's case.
Stand by. We'll get a file up here and we'll figure this out.
If it helps, I think I was originally supposed to be here last Friday, Thursday. Friday, I believe. I was on the calendar and it got moved for some reason to Tuesday.
You know, keep this. All right. I'm going to pull it up on court view and see what that tells me. I mean, typically that would mean a case went to grand jury and there was an indictment and it went from district court to superior court, but I don't want to guess at what we're doing without seeing. We'll get the file momentarily, I'm sure. Once we have a computer system that will tell me a lot if it just takes a while to open.
No problem.
And is Mr. Hicks present in person?
Yes, he is.
Thank you.
I don't know if, should I wait for anything?
Yeah, just stand by.
Okay.
All right. So court view shows charging document filed March 5th. Warrant was issued March 6th. And it looks like you must have been arrested on that warrant and posted bail.
I voluntarily turned myself in when I found out about it. I didn't
Well,
even...
an arrest, it's still an arrest whether you turned
okay.
yourself in or they hunted you down.
Yeah.
It's still considered an arrest. And,
Okay.
but you posted the cash bail, it looks like.
Yes, sir.
All right. And I think it was erroneously set on Magistrate Judge Curtin's calendar when it, I think, should have been set in Superior Court, because I'm assuming the initial charging document was an indictment, though I don't know that. Ms. Gibson, do you know if this is a case that's been to grand jury?
Yes, it has.
All right. So,
You have to win $20,000.
Are you seeing him?
Ms. Gibson, do you have a copy of the indictment that you could email to us?
Sure.
I need to arraign this gentleman, and I don't have a charging document to arraign. Did they give you a copy of the charges when you...
I believe they did, Your Honor, but I...
It's
okay.
All right. So,
Who
let me...
should I email him?
No,
You directly?
no, it's all right, I've got it now.
Okay.
I'm going to make a couple of copies. So we'll get some copies made of the charges. You've seen it, but I want to make sure you have a copy of it that you walk out of here with.
Thank you, I appreciate it.
So it charges misconduct involving a controlled substance in the third degree. Rules say I'm supposed to advise you of your rights at this point, which is that you have a right to remain silent. Anything that you say can be used against you in court. You have a right to be represented by a lawyer. If you can't afford a lawyer, you have a right to have one appointed to represent you. We'll get to the specifics in just 1 second. So this charge, it is essentially a charge of possession of a controlled substance, specifically methamphetamine, on or about June 24th of last year. That charge is a Class C felony offense under Alaska Statute 1171-040811C. I know that's all very technical. I am required to tell you what the maximum possible penalty is for that charge. If you're ultimately found guilty of this charge, the maximum possible penalty, the longest sentence that could possibly be imposed, is up to 5 years in jail and a $50,000 fine. Doesn't mean that that's what the sentence would be, but it's the maximum possible sentence. You want to have a lawyer represent you on this charge?
That'd be great.
Do you feel like you have the money to go out and hire one?
No, I've been unemployed since November.
Right, I need to ask some questions about your finances to make sure you qualify for a court-appointed lawyer. We need to get you under oath to do that. Could you please stand and raise your right hand?
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Go ahead, Steve. You said you've been unemployed for a while.
Since November, I'm a union electrician, just been on the books, waiting to go to work.
Okay, any source of income right now?
Appointment.
How much do you get unemployment?
$330 a week.
Okay. And how much money do you have to your name? I'm including cash on hand, money in the bank, under the mattress, wherever, whatever you got.
$300.
And do you own any item of property that has a value of $1,000 or more? Including a vehicle, a jewelry?
Well, I owe $5,000 on my vehicle on a loan, and I just paid off my trailer, so, in January.
And that's your residence?
Yes, sir.
How much do you figure the trailer's worth if you were to sell it?
About 60, 70 grand.
Okay. And any equity in that vehicle?
Equity.
You said you just paid it off, is that what you...
I did on the trailer.
Well, the vehicle you owe money on?
Yes, sir.
What kind of car is it?
It's a Nissan Titan.
What do you figure the...
2007, I don't know, probably about 5,000.
Okay. So, I suppose in theory, you could sell the trailer and raise some money. It is, I think, not the case that we would require you to be homeless in order to defend yourself on this charge.
Yes, sir.
And so I will appoint the public defender to represent you.
Okay.
Mr. Miller is here from the public defender's office. We got an extra copy of the charges for him. There's a co-defendant on here, and I don't... Ms. Gibson, do you know if the co-defendant has been arraigned at this point?
I'm checking, Judge.
Right. It does not ring a bell to me, but it is. I just want to see if the public defender might already have that case.
Mr. DeWeese was arraigned on the 9th of March, and public defender was appointed. And he has the May trial date, May 4th.
See that. Mr. Miller, I see your name is in court view as counsel for Mr.
Yeah,
DeWeese.
that's a familiar name to me.
Do you have any reason to think I should do anything to appoint OPA for this gentleman? If your office has already embarked on representation of the co-defendant, I would think that's a conflict here.
I don't know the policy of how it goes, if you directly appoint OPA or if it comes to us to get out of.
I'm comfortable directly appointing OPA.
But I think they want me to take them both and get out of one, but I'm not sure.
I mean, if you think there's the possibility your office might retain...
I think there's a possibility that we would retain him, because we haven't really got anywhere in the other case, obviously.
I'll just appoint the public defender and let your office decide that. So just, I'm getting into the weeds a little bit with Mr. Miller on the technical stuff, but when there are two defendants charged together, the same lawyer can't represent both of them. You each get your own lawyer.
Okay.
But the process is, I appoint the public defender for both, and they figure out which case they can keep. Sometimes they may have had they may have previously represented one individual, or they may have had some case in which one of you was a witness against somebody. They might have some reason why they need one case and get out of the other, and I let them figure that out. So I'm appointing the public defender's office. It's certainly very possible that you'll ultimately get a different lawyer, but that'll take a few days probably to get sorted out.
Great.
Mr. Miller can give you a phone number for you to check in with him and see if he's the guy or if it's somebody else.
Yes, sir.
I will go ahead at this point and set the same court dates that were previously set for Mr. DeWeese. It's possible that those dates will need to get changed later, but let me pull that up. Yeah. So, but I'll go ahead and set those dates. That means next court date is a discovery hearing, April 1st, 8:30 in the morning. So we'll be back here, April Fool's Day, 8:30 in the morning. And no fooling. And pretrial hearing, April 27th, 8:30. Jury trial, May 4th, 8:30. Doesn't mean the case necessarily will go to trial or that it will go to trial then, but I set those dates at this point.
Okay.
Let's see. Bail was posted. Ms. Gibson, any particular conditions of release other than the standard conditions that you would be requesting?
I think that PED with monitoring for controlled substances is appropriate. Other than that, I don't have a request. I think it's standard in co-defendant cases to order no contact or at least don't discuss the case, and so I'm expecting that would be a standard condition.
Does Ms. Gibson, does Mr. Hicks have any prior criminal history?
Yes. Actually, before I say yes with such conviction, let me make sure I'm not thinking about his co-defendants.
I would just note, I do have court view up, and there are some prior cases, DWI in 2012, violating protective order charge. I don't know if these are convictions or not. I can't really tell that from court view. Actually, it looks like that
2018. I'm sorry.
I disregard that case because it was dismissed. There's a DWI, though, back in 2012.
There's a 2018 violation of a protection order that was a conviction, the 2012 DUI, and another one in 1993.
According to court view, the 2018 violating protective order case was dismissed.
I believe there was more than one.
No.
Yeah, there's not more than one in court view. It looks to me like there was an SEJ and a set-aside, dismissed after successful completion of an SEJ.
Thank you.
We should notify NC or absent.
Yeah, it looks like there might be a glitch in the computer system on that. It happens sometimes and it can get fixed. I will disregard that. It does not appear that there are, if I'm reading this correctly, any prior felonies. There's a smattering of misdemeanors dating back into the 90s.
Correct.
Another DWI. So I would be inclined, because of the nature of the charge and the nature of the substance, to order pretrial enforcement, which means you're going to have to check in possibly for UAs. I will say that given what's going on right now, it's really going to be up to PED whether they actually want you to come into the office and do UAs. A lot of that's being done by phone right now, and I don't think you can give a UA over the phone.
Okay.
But I will order that you're subject to supervision by pretrial enforcement. You'll need to call them today or tomorrow. Mr. Miller, can you have a phone number? Do we
I
have cards?
do not have a phone number.
You're to appear in court as required. Next court date's April 1st. Stay in touch with the public defender's office, or if they forward you on to another lawyer, with that lawyer, and check in with PED on whatever schedule they'll set, which may include urine testing for controlled substances. If that's a problem for you, if you're struggling to stay clean, get out there and get some treatment and get to meetings, because that's a condition of you staying out on bail.
Sure.
Okay. And any reason why you can't stay away from Mr. DeWeese? Is he somebody you can't have?
No, other than he's my mechanic, but I can hold off. I get stuff done on my rig till this is done.
Full order that you're not to have contact with Mr. DeWeese while this is pending.
Okay.
And I think you'll need to go down to clerk's office and sign off on conditions of release, including the PED requirement. So, court is required, don't violate the law, PED supervision, drug testing, and stay away from Mr. DeWeese. Okay?
I just have a question.
Yes.
I'm not really sure what I'm being charged with, I guess. I wasn't even in town.
Well, sir, no, let me talk to me about that.
Yeah. Your lawyer will get the police reports, be able to go over this with you, which will give you an idea what this is all about. The charge is possession of methamphetamine. That's what you're charged with. So the specifics, I think that it would be better if you talk to your lawyer about that before you talk to me about it.
Yes, sir.
All right.
Thank you.
Ms. Gibson, anything else on this case today?
No, Judge.
All right. That's all I got. So go downstairs to the clerk's office, ground floor of this building, to sign some papers before you leave the building.
Yes, sir.
I can do it right now.
Oh, can you do it right now? All right. It was $2,500 cash performance, which has been posted. So, all right. We'll do the paperwork for you to sign right here.
Oh,
all right.
okay.
So stick around and sign papers. Otherwise, we're done.
Yes, sir.
We can go off record at this point.
Thank you.
All right. Thank you. I see Mr. Osborne here, who's on the calendar at 3:30, and we'll get to you in probably a couple of minutes. I got to do some paperwork from what we just did.
But the arraignment's not on the calendar board?
Or,
I'd say Calvin board.
Calvin board, yes. Actually, it is on the calendar. I'm sorry, I skipped that one. Is Mr. Board on the phone?
Yes, Your Honor.
All right, sorry. You were the first one on the list in alphabetical order, and I skipped right over you.
Just as Ms. Willoughby, I'm doing a limited entry of appearance for Mr. Board today.
Got it. All right. Do we still have DA on the phone? I think Ms. Gibson might have missed.
Your Honor, you've got, this is Ms. Gibson's case. If she's hopped off the phone, Ms. Wolfstead is still on.
All right. Ms. Wolfstead is with us, standing in for the moment for the state. Ms. Willoughby is on the line. Mr. Board this is really a continued arraignment. We've tried a couple of times, and Mr. Board was working to get counsel retained and had called in for Sitka. Ms. Willoughby, you want me to, I think we've completed the formalities of an arraignment. I think the charges were read to Mr. Board, and he's been advised of his rights. Any further advisement you think is necessary?
No, Judge, we would waive further reading and advisement. And enter a not guilty plea for Mr. Board.
I believe that the co-defendants' cases have been set for trial on the May calendar. They were actually originally set on Judge Mead's May calendar, but I believe that they've all been moved to my calendar because there was a reassignment, which would mean the May 4th trial dates. Ms. Wolfstead, I don't know if you know that. I can pull this up on court view and see if that's correct.
I can open it very quickly. Let me just pull up one of the co-defendants' cases, and this is the co-defendants, Mr. Watts and Mr. Carroll. And I can tell you that Mr. Watts and Mr. Carroll are on your May date.
All right. So, Ms. Willoughby, I think at this point, because of the co-defendants' cases, I would calendar this along with the co-defendants, which means trial date May 4th, 8:30, trial call April 27th, 8:30, Discovery hearing, April 1st, 8:30. Obviously, everything's a bit up in the air at this moment, and those dates, we may need to be revisited, but those are the dates I think I will set at this point, unless someone thinks I should do something different.
No, that makes sense, Judge. And the reason I'm doing a limited entry of appearances, I need to talk to Ms. Gibson about whether they're going to continue with these charges, because it's possible there was a Rule 11 agreement a couple years ago that encompassed these allegations.
I understood there was some question about that issue. So at this point, we'll set those dates. Mr. Board, I believe, has posted bail. Actually, I'm not sure if he posted bail, but he's out. I think he did post bail. So he did, Your Honor. Sitka, and the next court date is April 1st at 8:30, and you should work with Ms. Willoughby to make sure that things get sorted out between now and then we'll see where we are at that. Anything else we need to cover today on this case, Ms. Willoughby?
No, Your Honor.
No, thank you. No, thank you.
Mr. Board, any questions about any of that?
No, Your Honor.
All right, so we'll talk to you on the 1st. Thank you.
Thank you.
You can hang. Is there a question, Mr. Hicks? Waiting on paperwork. Got it.
Can I wait in here?
You're fine. Yep. Sorry for getting the down.
Armand?
W-E-E-S.
Judge, this is Ms. Willoughby again.
Yep.
Was Mr. Rogers set on for 2:30? I have him calendared to 2:30.
He actually is on the calendar at 2:30, and I'm sorry I jumped over him also. Mr. Rogers isn't here. Do we have a DA on the phone still?
Yes, Your Honor. I'm going to be here for the rest of your afternoon for this and for Mr. Osborne and for Mr. Classy.
We're still on the record, and Ms. Willoughby correctly points out that Christopher Rogers is on the calendar at 2:30. And Mr. Rogers his case has been continued multiple times, and I think each time Mr. Rogers has dutifully been in court. I don't see him here today, but I think each time his case has been on the calendar, he has reliably come to court and sat in the courtroom, I think on some occasions for an hour or two waiting his turn. I'm actually surprised he's not here today, given that. And I think there was a significant delay in getting counsel assigned to his case. Ms. Willoughby, are you going to be assigned counsel, or is it Ms. Soutier?
Yes, Your Honor. Ms. Soutier and I have worked it out, and I'm representing Mr. Rogers and entered an appearance today. So, and I don't know, did not talk to Mr. Rogers before this hearing, but he has sat in court quite a bit. I'm wondering if we can't continue this hearing to perhaps the end of this week or the beginning of next week, and we'll just get in touch with Mr. Rogers, and I'm pretty confident we can get him in.
The only little wrinkle in that is that the last hearing last week was a discovery hearing, and I think that I set this over for a continued discovery hearing. The state made the comment then that if this was continued, any offers would be off the table. Mr. Rogers has not, I don't know that he's yet had counsel, and so I want to be fair to Mr. Rogers.
I can correct that.
Yes.
It was not me. This is my case, Judge.
Yep.
I first off haven't been able to make an offer to Mr. Rogers because he has not had an attorney,
Right.
and certainly I'm not going to fault him for that.
I could do this one of two ways. We could continue this for a continued discovery hearing and leave it. I mean, I think this case is on the April trial calendar.
Mm-hmm.
I don't know if we're going to be doing trials on the April calendar. If we are, I suspect that we'll be doing Mr. Fuchs' case. And so it seems really unlikely that Mr. Rogers' case would go to trial April 6th. I could do one of two things. If Ms. Willoughby was willing to make a Rule 45 waiver, I could simply roll it to the May calendar and set it on the new discovery hearing April 1st. And I think I would feel comfortable, given that Mr. Rogers is not here, in finding that his non-appearance, together with counsel's acquiescence, waives Rule 45. Or we could reset it.
That makes sense, Judge. Let's do that, because that's what we would do if we had a hearing next week. If we continue this hearing, that's exactly what we would do. So it's not a good use of really limited court time to do that.
Right. Ms. Wolfstead, are you comfortable proceeding in that way?
Absolutely, Judge.
All right. I think Mr. Rogers has spent a substantial number of hours in this courtroom waiting for hearings, and given that, I guess I don't feel like I'm hugely troubled not being here today. Obviously, that might change if he's not at the next hearing.
I can say I've been there while he's been there as well, and he's been at every hearing.
And he's been patient and with a huge number of delays and wait, and so I'm willing to cut him that slack today. So I will order the matter continued until the May trial calendar, which means the next court date is April 1st, 8:30. Pretrial April 27, 8:30. Jury trial May 4, 8:30. Would find by virtue of counsel's agreement and Mr. Rogers' non-appearance that Rule 45 is told for that period of delay. Anything else to do on that case today?
No, thank you, Judge.
All right, thank you. Ms. Willoughby, I think that's
it.
It for you. Thank you for being with us. We'll let you go.
Thank you.
And again, Mr. Osborne is here. I need a minute to get, I still need to get paperwork sorted out, so we'll get to that just as soon as we can. Madam Clerk, do you have TOs for me, all of those other cases? Okay, I want to make sure we do that, particularly that reduced bail one. Whatever's easy. You got them and can print them out. I can fill them out fast. Yeah, come on up and have a seat. Do we have counsel for Mr. Osborne on the phone?
Joe Kovac here.
Go back, all right.
And Morgan Griffin, Your Honor.
Okay.
Theo Torgerson is also here for that hearing, Your Honor.
All right, thank you. I'm just getting to the right files here.
For Theo Torgerson's benefit, I anticipate this sentencing is going to get moved, sir. So rather than you sit around on the phone and wait, I can just give you the date of the sentencing.
That's a possibility. That would definitely be beneficial.
Okay. I'll email you.
All right. Happy to
Thank you.
Let's go ahead and go on record. All right, we're on record in State of Alaska versus James Osborne. Mr. Osborne is here. His counsel are on the phone, Mr. Kovac and Ms. Griffin. We have Ms. Wolfstead with us on the phone for the state. Matters on the calendar for sentencing, set quite some time ago. And Ms. Wolfstead, I don't know if I should turn to you or defense counsel. You said this sentencing may get moved. What's going on?
Yes, Your Honor, and I apologize. I didn't mean to rush you in whatever else you were doing. I was just trying to save the probation officer some time.
Oh, that's fine.
I'm actually covering for Ms. Kemp today. I'm just looking at a series of emails, I guess, in which Mr. Kovac had mentioned moving the sentencing out a bit, and Ms. Kemp not opposing that. So that's where my anticipation came.
And Your Honor, Joe Kovac here, if I could speak more on that issue.
Yes.
Thank you. Your Honor, my client's mother has been trying to bail him out for some time now. She actually did post the money days ago, but there's been some sort of hang-up with PED. not being able to get anyone to go put an ankle bracelet on him.
He's here and not in custody, though.
Oh, are you out of custody, sir? Oh, goodness.
Actually just released me this morning.
Okay, good. In that event, Your Honor, that's a good thing. I'm going to need some more time to speak with my client, so we're going to have to put off the sentencing a little bit. In the meantime, though, I was speaking with Ms. Kemp, as the prosecutor indicated. Mr. Osborne there's a no-contact order right now, Your Honor. In fact, the victim, when we were last in court in December for the change of plea, she requested that the no-contact order be dropped. She wanted to have contact. Their child was just born not long ago. I believe her first birthday is coming up. Back in December, Your Honor said that you would take that under advisement because I believe that the state did oppose over the victim's wishes. But we've not seen anything from the court yet as to a decision on that no-contact order. Ms. Kemp, though, for the meantime, is non-opposed to allowing contact, at least for the child's first birthday party, which, again, is coming up here in a few days. I did just call the victim minutes ago. I provided her the number and the code. I don't know if she has called in yet, but she did say that she intended to do that when I spoke to her. Again, not minutes
I believe
ago.
that's Williams. Is Ms. Williams on the phone? That sounds like we have her. All right. When's the child's birthday?
On the 20th.
How far out are you asking to move this, Mr. Kovac?
Not far at all, Your Honor. Just let me, if I could take a look at my calendar one moment. Your Honor, the end of next week or the beginning of the week of the 30th would work for me.
Ms. Wolfstead?
Either will work for us, Your Honor.
You want to say anything about the issue of the no-contact order, Ms. Wolfstead?
Your Honor, I guess I have a little more information than I normally would on somebody else's case because I was the person that indicted Mr. Osborne when Ms. Kemp was out of town. I would agree with still opposing the general ability to have contact, but I will say that Ms. Kemp does not oppose allowing Mr. Osborne to go to the child's first birthday party.
Does Ms. Williams, is she living in Juneau now with children? Is she here in town, Mr. Osborne, as far as you know?
No, she is not.
She's in Yakutat.
Yes.
When we're talking about contact for the child's birthday party, I mean, are you talking about going to Yakutat, or is that going to be in Yakutat, or what's the plan as you understand it?
I was hoping that they would be able to come here and at least be able to attend that.
Understand. All right. So let me first address the sentencing date. End of next week probably isn't good. I could do it the following week, which is 2 weeks out, the week of the 31st. Monday's a holiday that week. I could do it either Tuesday or Wednesday afternoon. Any preference on the part of counsel for either of those?
I'll defer to
Your
whatever
Honor,
works best.
for the 31st. Oh, I'm sorry.
Go ahead, Mr. Kovac.
Your Honor, I didn't mean to interrupt. I was saying that the afternoon of the March 31st works for me.
I could do it at 1:15 on the 31st, Tuesday the 31st.
Okay.
I want to look at one thing first. Let's see. So, Mr. Osborne, do you have a bracelet on you from PED?
Yes.
Is that an alcohol monitoring bracelet?
Yes.
I guess I feel like that gives me some comfort that there can at least be some reason to believe that Mr. Osborne's not going to drink. I think in the past some of the problems have been alcohol related, and that's not an issue now because there's a bracelet on. I know that Ms. Williams has been asking for contact to be allowed for a long time. She's been to court and has told us that, or has been on the phone and has told us that. And that no contact order has been in place for a really long time. This is, the original assault that was charged here is really serious. And so I have some concern about things going off the rails. We're going to be here in 2 weeks for sentencing. We're not in a situation where I would have concern about, improper influence being exerted on a potential witness because it's not a pretrial case. And that's the main concern. I think that long-term contact is probably going to require Mr. Osborne to be participating in some programming and some things that aren't going to be in place in the next 2 weeks. But I guess given the delay in getting this dealt with, I'm going to allow contact at this point. So I will lift the no contact order. I will say that if Ms. Williams asks you to be away from her and not have contact, you comply with that.
Yeah.
So that'll be the condition of release, that if Ms. Williams, as long as Ms. Williams is okay with it, contact is allowed, but if she asks for contact to end, then there's not to be contact by you. So you comply with her wishes about that.
Yes.
Okay. So you get to be around her and the child, and then we'll come back on the 31st and see where we are. 1:15, 31st, sentencing. Anything else right now, Ms. Wolfstead?
No, Your Honor.
Mr. Kovac, anything else right now? Mr. Kovac, anything else?
Oh, I'm sorry, Your Honor, I still had it on mute. Yes, I was wondering if I can confirm if my client has my phone number.
Yes, I do.
All right.
Okay. Stay in touch with me, sir.
I will.
All right. You're free to go.
Thanks so
Judge,
much.
this is Morgan Griffin.
Yep.
If I could, in light of Mr. Osborne posting bail, there is a pending bail request here, a bail hearing request. If I could just...
Mr. Osborne, stick around 1 second. Hold on. Yes?
There's a pending request for a bail hearing in the 1JU case, and because he's posted bail, I've just asked the court to withdraw that request, just so the court's not still trying to schedule something later.
Got it. Thank you.
Thank you.
You're free to go. Thank you. Yeah.
May be excused, Your Honor?
Yes, sir.
Thank you.
We've got a 4 o'clock with Mr. Clasby. Mr. Side, are you doing that? Are you there? I'm not sure if we had. All right. Still early. We'll go back. We'll reopen the line when that time comes.
Okay, then I'm going to go ahead and hop off the line and call back in about 10 minutes. If that works.
All right. Mr. Clasby's up in Anchorage.
Thank you.
Oh, it's for 4:15. He said send an email for 4:15.
Oh, okay. It said 4 o'clock on the calendar.
The chairperson has disconnected. The conference will now end.